Please. It's a additional list. Additional list is documents. They are forming a part of the charge sheet itself. This is the regular bail application in connection with FIR B, Morbi B division CR number 11890040220003 for the offences under 304, 308, 336, 337, 338 and 114 IPC. This is the first regular application, sir, after the filing of charge sheet. On the earlier occasion, the present applicant had moved this honorable court seeking anticipatory bail. While criminal miscellaneous application number 40 of 2023, which by order dated 1/2/2023 came to be disposed of as withdrawn. The orders have election meeting and raju karo. Apart from this, there was one temporary bail application which was filed, which has been rejected. Regular bail applications have a penalty after the filing of charges. Now the case of the prosecution in the charge sheet against the applicant, who happens to be the director of Oreva Group of Companies, is mentioned in the charge page 35. About five-fold allegations, she said. Your Honor has dealt with bail applications of the various co-accused in the present case. Your Honor is aware of the facts. But if I briefly state, the company was assigned with the task of the maintenance of the bridge not from 2022. The maintenance of the bridge was assigned to the company since the year 2008. And these are undisputed facts, sir. Post the earthquake, the functioning of the bridge had stopped. It was only after the intervention of the corporation, Rajkot Municipal Corporation, through the Morbi Nagarpalika, that an offer was made to the applicant's company that will you be able to maintain the bridge as a heritage of this city. And I said, kindly appreciate, I am into the business of digital clocks and lighting products. Since years, since decades, there are more than 2,000-3,000 people who are under my employment. Now, after this unfortunate incident, the prosecution is trying to create a picture as if Maru construction no kaam hatu aa bridge. And as it is an undisputed fact that since 2007, I was maintaining this bridge. No untoward incident till 30th of October 2022. Not a single untoward incident. कोई साहब नगर पालिका है चिट्ठी लिखी है हमारा कंपनी ने in all these 15 years that you are not maintaining this bridge properly. તમે આ બ્રિજ નું સુપરવિઝન બરાબર નથી કરી રહ્યા હતા આવું કઈ જ નથી till the date of the unfortunate incident. 2007 માં સાહેબ જ્યારે એગ્રીમેન્ટ 2008 માં મોરબી નગરપાલિકા જોડે થયું, it happened initially for a period of 9 years. That term expired in 2017. From 2017 to 2022, it was I, the applicant, who was writing to the Nagarpalika. The period the bridge now requires renovation once again. Our contract is also over. It is in March of 2022 that an MOU is executed between the Nagarpalika and my company, to be specific, on 7th March 2022. इसे अब आज जे मैं एडिशनल लिस्ट रजू करी है ना, एनेक्सर एफटी रजू करी है, MOU है. Now kindly see the MOU, sir. 7 માર્ચ 2022 નો MOU છે. એમાં જેવી 3 conditions હતી એ પ્રમાણે I had to seek do the renovation of the bridge. Now what are they alleging? કે 7 માર્ચ 2022 ના MOU માં as per condition number 4. હવે I will go by allegations. The first allegation is કે condition number 4 પ્રમાણે you as a company said કે આ bridge ના renovation માં કરીબન 8 થી 12 માસનો સમય લાગશે. તમે એને ઝડપથી પૂરો કરીને ચાલુ કરી દીધું. This is the first allegation. કે condition number 4 પ્રમાણે 8 થી 12 માસમાં આનું renovation નું કામ, it was your company which said કે 8 થી 12 માસમાં આ bridge નું renovation પૂરું થશે. પણ તમે એના કરતા વધારે ઝડપ સ્પીડમાં આનું renovation પૂરું કરી દીધું. Pausing here for a moment, sir. It is not their case કે renovation થયું જ નથી. Kindly appreciate this. I can understand કે 7 માર્ચે સાહેબ મેં એગ્રીમેન્ટ એક્ઝિક્યુટ કર્યું અને મેં 15 માર્ચે બ્રિજ ખોલી દીધું વિધાઉટ એની રેનોવેશન. રેનોવેશન તો સાહેબ થયું જ છે. રેનોવેશન which has incurred an expense of rupees around 1.25 crores to me. એટલું તો થયું છે. This is their case only. They are only saying કે 8 થી 12 માસનું તમે ટાઈમ કીધેલો, તમે આ કેમ 7 મહિનામાં ખોલી દીધું બ્રિજ? This is their allegation. The second part of the allegation is કે તમે આ કર્યું to derive financial benefits. કે તમારે financial benefits derive કરવાના હતા. Now at the cost of repetition, sir, like I said, I took up the task of maintaining this bridge as a public spirited citizen, to see to it that a heritage site of the city is maintained, to see to it that the heritage site is visited. And now the prosecution is alleging that either I had the knowledge or I had the intention, after maintaining the bridge for around 15 years, to see to it that there's a bridge padi hai. Because that is how they are charging me for 304. The second part of the allegation is કે મેં આ કંપનીના રિનોવેશનનું કામ એક દેવપ્રકાશ સોલ્યુશન નામની ધાંગધ્રા સ્થિત કંપનીને આપ્યું, જેને આ રેનોવેશન કરવાનું કોઈ એક્સપર્ટીઝ બી નહોતું અને એને આ પ્રકારનું કોઈ રિનોવેશન વર્ક કરેલું ન હતું, એને નોલેજ પણ ન હતું. In this regard, kindly take judicial notice of this aspect, sir. In the charge sheet, accused number 8 and 9, first charge sheet, are one father and son. Son is involved now in Devprakash. The father was involved in the running a business in some other way. 2008 થી સાહેબ renovation કે repairs નું કામ મારી કંપની આ ફર્મને જ આપતી હતી. And it is not as if this was not in public knowledge. સાહેબ માર્ચ 2022 માં મારી જોડે પહેલી વાર બ્રિજ મેન્ટેનન્સ કે રિપેરિંગ કે ઇનોવેશન નું કામ આવ્યું હોય. Before the unfortunate incident in October, I can understand for the municipal corporation or for that matter the Nagar Palika to say कि हमने खबर જ નથી. These are the same very people who have undertaken the task of repairing the bridge in the year 2008. It is their case. એમના charge sheet में हमने લખ્યું છે. In the year 2008, it was accused number 8 who undertook the task of renovation. In the year 2022, it is accused number 9 who happens to be the son of accused number 8. જેને આ કામ આપ્યું. The third part of the allegation in the charge sheet is that after the renovation work got over, I chose not to get the bridge technically examined by conducting relevant technical tests and I got certification. This is their allegation. In this regard, kindly see, MOU what they are doing is they are conveniently reading the MOU. જ્યાં એમને લાગે ત્યાં કહેશે કે MOU ના શરતનું પાલન કર્યું નથી અને જ્યાં એમને લાગે ત્યાં કહેશે કે MOU વંચાણ જ નહીં લેવાનું. if they want to say that I have not stuck to the contents of the MOU, then in my respectful submission, the MOU has to be read in its entirety. MOU માં આવું ક્યાંય નતું લખ્યું that I had to undertake the task of certification also. અને 2008 માં as well as 2022 માં the repairs and renovations happened in full public clear. This was a long bridge, sir. એવું નથી કે આ બંધ બાયણે આ repairing કે થયું. At no point of time there is any written, any oral, leave alone any written communication by the Nagarpalika saying કે ભાઈ તમે આ repairing કરી રહ્યા છો, ખોટું કરી રહ્યા છો. There was no objection raised. There is no communication indicating that your task of renovating this bridge is not up to the mark. Then there is the fourth allegation which says that MOU na condition number 1 प्रमाणे તમારે 5 बार 70 रुपया टिकट, તમે 5 बार 70 रुपया टिकट उगराई instead of 5, 10, 15. This is the allegation that this rate was applicable from the year 2023. But I started collecting, or the ticket collectors started collecting this from 2022 itself. Kindly see, the original amount is 510.15. The collected amount is 512.70. So it is an increase of 2 rupees per day. So it is not as if that I had told the Nagarpalika that who 15 rupiya ugarais as ticket, and I started collecting 1,500 rupees. This they say that I itla karyu because I wanted to derive financial benefits. Now in my bail application, sir, I have annexed a list of donations that I have made over the period of years. In the additional list of documents, I have annexed the expenses that I have incurred in the renovation of the bridge, both in the year 2008 and in 2022. The estimated cost of expenditure in the year 2008 was around 35 to 40 lakhs. In the year 2022, it was close to more than 1 crore rupees. And they are saying that 5 દિવસ માં મેં એટલા બધા લોકોને મૂકી દીધા. The idea was to derive financial benefits. There is nothing on record which says that this was the maximum strength, and this I say with utmost humility at my command. This is a very unfortunate incident that has happened. But now to turn back against me and say that you did all this because you either had the knowledge that the bridge will collapse or you had the intention that the bridge should collapse. This is unfair in my respectful submission. Over the periods, this I've annexed it with annexure D. Over the period 2015, 2016 to 2021, 2022, my company has given public donations to the tune of rupees 4 crore rupees, more than 4 crore rupees to various organizations, various self-help groups. And then, what is the financial benefit which I was to derive? I had no, kindly appreciate 2008 maybe the approach to my company was through a project which is called Public-Private Participation Project. It was the collector Rajkot, MI was there 2001 on account of the earthquake. The famous Jam Tower of Rajkot got damaged. It was my company which renovated to keep it as a cultural heritage of Rajkot city. Based on the work that I did as a philanthropist. મારે સાહેબ આ ધંધામાં રિનોવેશનના ધંધામાં ટાવર બ્રિજ આ બધા બનાવવા નથી થતા. This is not my business, and this is also an admitted position. Based on the work that I did as a philanthropist, as a public spirited citizen, in 2008 I was approached. Say, here is a bridge જે બંધ પડ્યું છે. This is in your city. Would you be able to maintain it for maintaining the heritage of the city? This was the only purpose of maintaining the bridge for the last 15 years. The fifth allegation, the fourth and the fifth allegation is that I opened the bridge without informing the concerned authorities, and that I opened the bridge without taking due care and precaution with respect to the various safety measures. क्या लाइफ गार्ड તમે રાખ્યા નહીં, क्या તમારે જે સેફટી મેજર્સ હોવા જોઈએ એને તમે રાખ્યા નહીં. You didn't have enough manpower before opening of the bridge. Now, as far as the opening is concerned, sir, kindly appreciate. The bridge was opened for the public on 26th of October within full public glare. There were advertisements which were put across the city that the bridge will be opened for the public from 26th of 10. And between the period that the bridge was getting renovated, since the time 26/1/2022, finally I, as a caretaker of the bridge, took a conscious decision that our bridge public માટે બંધ કરી દેવું જોઈએ. From 26/1/2022, 26 થી જ્યારથી આ bridge બંધ કરવામાં આવ્યું for public access, to 26th of 10/2022, the prosecution may show that I allowed public access. If they fail to do so, which in fact is an admitted position, that 26/1/2022 થી 26/10/2022 સુધી the bridge was not open for public access. It was undergoing renovation. Then at best they will say that આ ત્યારે કે હોનારત થયો તો I was responsible. 26/10 જ્યારે bridge નું opening થયું, it happened in full public glare. Everyone knew that the bridge is now to be made accessible to the public. The corporation, or for that matter the Nagarpalika, did not utter a single word, no communication. No, and I said, "Aje je mane ke che, ke you did not do this, you did not do that." The property is owned by the Nagarpalika. That is an admitted position. Mari to say personal property che nahi. I got involved as a philanthropist, as a person who wanted the heritage to be maintained. What stopped the Nagarpalika to say કે ના અમારે પહેલા ટેસ્ટ કરાવવા છે? We want to see to it કે શું renovation થયું છે. The very act of the Nagarpalika not doing anything goes in my favor, that there was nothing wrong in the renovation work done. And then they say that you didn't check कि कितना लोगों ब्रिज ऊपर जई રહ્યા છે. But what is the actual strength of the bridge? એ તો રેકોર્ડ ઉપર ક્યાં આવતું નથી. There is one statement of a witness from the Nagarpalika who says કે રજવાડીના જમાનામાં 15 લોકોને પરમિશન આપતા હતા. From that time till the time of the incident, what was the actual number which was proper for that bridge to stand on its own? Is not coming on record. And they are now alleging that because of overcrowding, because my employees did not keep a tab, they kept on selling tickets and tickets, the bridge got overcrowded. But who is to decide that in absence of any material which says that કાલે ઉઠીને સાહેબ આપ બ્રિજની સ્ટ્રેન્થ 1000 માણસની હોત? We don't know. Or they may say, એક સ્ટેટમેન્ટ જેમ મેં કીધું કે જે તે વખતે when this was under the regime of the princely state, 15 people were allowed. એ સ્ટેટમેન્ટ છે. એના પછી જે જ્યારે કોર્પોરેશન યુઝ કરતું હતું, or for that matter નગરપાલિકા આ બ્રિજને મેન કરતું હતું, whether there was a limit, if yes, what was this sanction limit? એ બધું ક્યાં રેકોર્ડ ઉપર આવતું નથી. And they then say કે લાઈફ સેફટી જે સેફટી equipments છે એ તમે મેન્ટેન રાખ્યા નહીં. Pausing here for a moment, there is nothing on record that when the bridge was manned or taken care of by the Nagarpalika, such safety equipment stood at place. And between 2008 to 2022, મને કોઈ communication એવું કરવામાં આવ્યું નથી કે why are there no safety equipments on the bridge. There is nothing in the MOU also. એટલે સાહેબ આપણે કીધું MOU where they feel that we should read, they are saying કે MOU નો શરતનું ભંગ કર્યું છે. Where the MOU is conspicuously silent on other aspects, they don't want to rely on the MOU. And like I said, sir, this indeed is an unfortunate incident. We cannot run away from that fact. There is a so moto PIL. There is a so moto PIL proceedings going on before the Honorable High Court. In my bail application at Annexure E, in fact, in those so moto PIL, I have been joined as a party respondent. And this again I am saying with utmost humility. My act of volunteering to compensate, I am not doing a favor to anyone. But I also feel, as a citizen of this city, that because there has been such a large, I also felt that because there has been such a large number of casualties, I volunteered on my own through my company that I was ready to pay 5 lakhs to the teeth and kin of deceased and 1 lakh to the injured. The Honorable High Court said no. You will pay 10 lakhs to the teeth and kin of disease and 2 lakhs to the injured. Your Honor may see Annexure E, page 44. On 14th of March, I have already deposited 7 crore 31 lakhs before the Gujarat State Legal Services Authority, pursuant to the orders passed by the Division Bench of the Honorable High Court. And a Bijo Sahib draft, आज एडिशनल लिस्ट साहब ने आज रजू કર્યું ને એ ડિમાન્ડ ડ્રાફ્ટની કોપી में એનેક્સર H3 બીજા 7 કરોડ 31 લાખ ની ડિમાન્ડ ડ્રાફ્ટની કોપી છે issued in favor of again Gujarat State Legal Services Authority. It will be deposited by the end of this week. એટલે ડ્રાફ્ટની કોપી રજૂ કરી. The charge sheet has been filed. There are no criminal antecedents of the applicant. There are around 460 witnesses who have been cited as witnesses, have deep roots in the society. Sir, three judgment खाली रजू करूँ खाली relevant paragraphs से आपका ध्यान करना है. Sir, not read. જે પહેલું છે સર એ છે 2015 GX ગુજરાત 76 એના રેલેવન્ટ પેરાગ્રાફ નો ઉપર ફર્સ્ટ પેજ ઉપર જજમેન્ટના ફર્સ્ટ પેજ ઉપર લખેલા છે 2, 3, 18 અને 19. એવી જ રીતે સેકન્ડ જે જજમેન્ટ છે એ 2, 4 અને 17 રેલેવન્ટ પેરા અને ત્રીજું જે છે ત્રીજું સાહેબ ખાલી થોડા ફેક્ટ્સ આપણે ત્રીજાના કહ્યું. The third judgment though is a judgment on anticipatory bail. It is in connection to the famous Bhuj tragedy that happened in the state of Gujarat. And the applicants before the Honorable High Court were again directors of a company. J company no methyl was alleged to have been used in preparing their food. Those are the facts of the but also bail again, sir. And that is a judgment on anticipatory bail. I, in my respectful submission, stand on a better footing. एना भी relevant paragraph साइड में ऊपर लगेगा. Subject to what my senior learned friend is to say, I am obliged.
Please, Your Honor. The first thing is that what is seen, observed, and narrated by my learned friend with respect to narration in the charge sheet is the summary of investigation. It is not a final conclusion of investigating officer. in whatever words, in whatever way he likes, he summarizes the conclusion in his own way. It is for this honorable court to finally conclude whether offence is made out in view of the summary of the charge sheet or not. So to say, and to give a serial number that first allegations against me, second against me, third against me, it is suited to his case, therefore he may say, he has right to say. But I am not saying that investigating officer says only this. He selects a certain portion of the conclusion and says that these are allegations. In selecting and choosing those portions of the charge sheet, my learned friend is conscious enough to mix up illegalities and irregularities. All those things which my learned friend submitted falls into the category of irregularities, like charging 5 rupees instead of 2 or 3 rupees instead of 2, employing certain chowkidars on the 2 poles of the bridge, whether these things were included in the contract or not. Everything falls under the category of irregularities. And all those things are for the government to decide whether any irregularity has happened or not. In my humble submission, which part of my learned friend's submissions are relevant for disproving the case of the prosecutions against the present accused under section 304? The foundation of the case of prosecutions against these accused under 304 is that bridge collapsed. If bridge had not collapsed, then there was no offense made out. Now, how the offense is made out can be observed and heard from the submission of my learned friend himself, because he himself says that 2008 થી renovation ચાલતું, repairing ચાલતું. From 2008, if you were repairing the bridge, and finally in 2021, if you had to close down the bridge to reopen in 2022, then what you did for 13 years, and why there was a need to close the bridge for 1.5 years, and what led you to open the bridge again? So what type of repairing was being done in the span of 14 years? That in spite of 14 years of repairing, everything collapses? What repairing was being done? So the facts which throws light upon the offenses and the factors which constitute the offense are not discussed by my learned friend. He simply says that these are irregularities, everything was in the public glare, and therefore everybody could have noticed. So what my learned friend expects, that all those who are passing upon the bridge should look at the cable and satisfy themselves that yes, these are safe. These are not the expectations from the present accused. When something is given by the government by way of contract to renovate or repair a bridge or a public property, the scope and the tenor of renovation and repairing depends upon the condition of the bridge. We cannot say that this was not included. Moment he says in January 2020 that the bridge is likely to collapse because it has deteriorated, it has become dilapidated, then the scope and the inclusion in the reparation and renovation becomes widened. Then he cannot say that this was not included, this is not stated in the contract. Nothing is relevant. Supposing there was no contract at all. On oral consent, you were granted the reparation of bridge. Then what was your responsibility? To make sure that all the cables are strengthened, the bridge, to make sure that bridge does not collapse. These are the things which were of utmost relevance to constitute an offense. Now, in this regard, what is the submission? Whether Nagarpalika was knowing, whether it was in the public gaze, report is that, Your Honor, that out of 84 wires, 41 were broken. The breaking of the wires had not happened because of fire which caused melting of the wire. It happened during a span of 15-20 years. And that also during a time when the present accused says that yes, we were undergoing repairs. So was the repair meant to strengthen the bridge, or to weaken its strength. For 14 years, if you repaired it, then why it ultimately collapsed? There should be some reason. Now it is for him to come up and say that, see, the bridge had not collapsed because of any dilapidation or because of any lapses on the part of the accused. Nothing of that sort. Instead, finding fault with the case of the prosecution that this is not done, there is no such thing, public gaze, government officers were knowing, 26th it was opened, 30th it happened, but ultimately what? Let us consolidate and comprehend all these submissions made by my learned friend. Does it disprove the case of prosecution or does it suggest that accused is not guilty? In which way? Therefore, in my humble submission, kindly compare the presentation of my learned friend and as a prosecutor, which I am presenting to prove the case. I am simply saying that these are three facts which constitutes the offense. If it appeals to my learned to this honorable court, then immediately the burden shifts upon him to show that how the submissions made by my learned friend disproves the case against him. In no way it disproves in my humble submission here. Second thing may be considered. We know the principle of parity. If these accused had obtained the bail, succeeded in getting the bail, then rest of the accused could have said that we have played a lesser role and therefore much less parity, but we are still on a better footing and therefore kindly release us on bail. Those people, those 9 accused whose bail application has been rejected, who stated that we are simply sitter acting at the behest and on behalf of the present accused, their bail has been denied, then how the present accused can say that kindly release me on bail? His role is larger than all those accused whose bail has been rejected. And as I have been given to understand, 3 or 4 of the bail applications are today fixed for hearing by Honorable High Court. We do not have yet the decision of those cases. Even if those bails are allowed, in my humble submission, still the role of the present accused is larger than all those 9 accused, co-accused. The orders cited by my learned friend, in order to convince this honorable court for exercising discretion, he has pointed out in 2015 GLH, Justice J.B. Pardiwala's order, Your Honor, wherein para number 2, 3, 18, 19 have been cited as relevant paragraph. But in my humble submission, Your Honor, these are not relevant paragraph. Relevant paragraph is paragraph 60, which I may be permitted to read. I will hardly take 1 minute, Your Honor. That what has been considered by the Lordship to release the accused on bail, that is relevant, Your Honor. What were the facts? What was the law? How many citations were produced? These are not relevant. What Lordship considered to exercise discretion is relevant. And para 16 says that what Lordship have considered. Taking into consideration the request of learned APP, I do not propose to enter into appreciation of evidence at this stage, which is otherwise also not permissible for the purpose of probing whether any prima facie case is made out against the applicant, so far as the offense under 304 Part 2 IPC is concerned. However, I may assign reasons in brief, since I am inclined to exercise discretion in favor of the applicant. Now, what was considered? First, investigation is over. Charge sheet has been filed for the offense under Part 2, 337 and 338. Applicants are all employees of the Spectrum Techno Consultant Private Limited, a company engaged in the business of comprehensive consultancy services for various infrastructure projects. Discretion was exercised because Lordship was dealing with the case bail application of those accused who were merely employees of the company. Forget about the present accused. Is any of the co-accused employee of the company? In my humble submission, no, because he himself says that he is engaged in the business of electronic infrastructure. Building, repairing bridges is not his business. So anybody who is taking care of the building or monitoring or observing the reparation and renovation of the building, of the bridge, were not employees here, because his main business is electronic items. So even otherwise, even if it is not his main business, even if this is his main business, still nobody is his employee. Only the two, manager. third thing considered, the investigating agency collected two different reports from two different committees. One committee opined that the accident occurred on account of the defective design of curvature in the flyover for which the Spectrum Techno Private Limited may not be held responsible. There were two reports of the rival committees which was contradicting each other, and therefore Lordship exercised discretion. Same bill, flyover collapsed. Out of 68 spans, 64 were intact. Only one span of the flyover collapsed when the support were sought to be removed. Moment supports were removed, the span collapsed. Now, this is the facts on which the discretion was exercised. How in this case it can be relevant? Now, another order cited by my learned friend is 2009 GLS. In that order, my learned friend cites para 2, 4, and 17. Again, 2, 4, and 17 are not relevant, Your Honor. 18 is relevant, wherein the Lordship narrates that what are the facts which Lordship have considered to exercise discretion. Examined in the light of the above principle of law, and as already discussed earlier, in the present case, the material on record does not indicate that there is prima facie case against the applicant or reasonable ground to believe that he is involved in commission of offense. Now, by what stretch of imagination we can say that this accused is not involved in commission of offense, or there are weak grounds to prove case against him? On the contrary, he admitted his civil liability before Honorable High Court. We are dealing with only criminal liability. So the liability and the reason for collapse of the bridge is not at all in dispute. What my learned friend disputes is the irregularities which has nothing to do with the commission of crime. In the third order which my learned friend cites, wherein anticipatory bail was granted, was pertaining to Hooch tragedy, wherein there are two types of alcohol, Your Honor, methyl and ethyl alcohol. Ethyl alcohol is always used for human consumption. It is not harmful. But methyl alcohol causes blindness. It causes many other effects also, but methyl alcohol invariably causes damage to the body. Now, under that circumstances, why Lordship was pleased to exercise discretion? Because the Hooch traveled in number of hands, and originally there were 600 liters of Hooch which came out of the factory, and ultimately, finally, when the accused with which the Hooch came was holding only 1 liter. Under 1 liter of Hooch in his possession, he was sought to be inculcated. The relevant paragraph by the right-hand side is 3, 6, 13, 15, 3, 6, 13, 15, and 16. But in my humble submission, Your Honor, the relevant para is para 13, wherein again the Lordship has been pleased to narrate the grounds on which the discretion was exercised. 13.1, 2 are narrated, and 13.3 is most relevant. It also appears that transaction of selling methyl alcohol was not a continuous transaction, more particularly in view of the fact that prior to 600 liters being stolen and sold, Jayesh had for the first time given 1 liter methyl alcohol as a sample to the co-accused for testing. Now, Jayesh bail was being argued. He had only 1 liter out of 600 liters which came out of the factory. And therefore, the discretion was exercised that for 1 liter, he cannot be held for the death of 10, 15, 46 people. So therefore, in my humble submission, Your Honor, Lordship has too much of wisdom than what we have. When they exercise discretion, it cannot be superfluous. After, in spite of these many judgments like Sanjay Chandra and everybody, if the Lordships are pleased to observe that the discretion is required to be exercised, then we have to understand that there must be some glaring facts which were tilting in favor of the accused. Then only the discretion would be exercised. In this case, Your Honor, what are the grounds which my learned friend has stated to exercise discretion in his favor? So therefore, in my humble submission, no case is made out. Therefore, the bail application, though charge sheet has been filed, requires to be rejected for the simple reason that filing of the charge sheet is a relevant event here. But sometimes it is stated that it is change of circumstance. But indeed, it is change of circumstance, but the change should be of such a nature which points towards the innocence of the accused. That is the change which is relevant for exercising discretion. If the change by filing the charge sheet suggests that there are a number of proof against the present accused which were available at the beginning of the investigation, then bail requires to be rejected.
આર્ગ્યુમેન્ટ આપું છું હમણાં 10 મિનિટ
સબમિશન છે
હા હું આ કોપી આપું છું સાહેબ હમણાં 10 મિનિટ
મારે એક જ લાસ્ટ સબમિશન ઉપર એક જ કાઉન્ટર સબમિશન છે. This applicant has not preferred any application before the filing of charge. So for my learned friend to say that it is only a cosmetic change, it is not as if the charge sheet pehla. One of the grounds which weighed with this honorable court for rejecting the regular bail of co-accused, one of the grounds was કે એમણે ચાર્જ શીટ પહેલા બેલ ફાઇલ કરેલી, એમની ચાર્જ શીટ પહેલાની નામદાર ગુજરાત હાઈકોર્ટ સમક્ષ બેલ વિથડ્રો થઈ ચૂકેલી છે. Therefore, mere of filing of charge sheet cannot be considered to be a circumstantial change.
હા સાહેબ આવે છે રાજકોટથી આવે છે. મોરબી સિટી એ ડિવિઝન કોર્ટ ગુના રજિસ્ટર નંબર 146 ઓબ્લિક આઈપીસી ની કલમ 379 તથા 114 મુજબના ગુનાના કામે હાલના ગુનાના કામે એફઆઈઆર જોવામાં આવે છે તો જેમાં અમારું નામ નથી. કલમ સજાની જોગવાઈ જોવામાં આવે છે 3 વર્ષની સજાની જોગવાઈ નામદાર નીતિ અદાલતની ફાઇલ ચલાવવાની સત્તા હોય. હાલના ગુનાના અન્ય આરોપી સામે છે ચાર્જશીટ થઈ ગયેલો છે, જેનો કેસ પાસે ફેસલ થઈ ગયો છે, જેનું જજમેન્ટની નકલ આ સાથે રજૂ છે. હાલના ગુનામાં છે અમને ચાર્જશીટમાં નાસ્તા મળતા બતાવ્યા છે સાહેબ, જેમાંથી સાહેબ અમે 6 વર્ષથી તો અમે જેલમાં હતા અન્ય ગુના. સાહેબ અમે સ્થાનિક રહેવાસી કે નાસી ભાગી જે વ્યક્તિ નામદાર કોર્ટ જે સંસ્થાઓ ફરમાવશે તેનું પાલન કરીશું, જેથી સાહેબ યોગ્ય રકમના જામીન બુક કરવા આવે છે.
મારે ફાઇલ જે છે ને પીએસઆઈ 12 ડિવિઝન આવે છે, પીએસઆઈ સોનારા એ ડિવિઝન. એ ફેક્ટ એવી છે કે આજે અરજદાર છે એ લાંબા સમય પછી મળી આવ્યા છે, વોન્ટેડ હતા 2014 થી 21 સાહેબ એ નાસિક જેલમાં હતા અને જે ઈ ગુજકોપ જે સોફ્ટવેર છે સાહેબ ગુના બાબતે એ સાહેબ 2015 માં આવ્યો એટલે 2015 પહેલાના કોઈ ઓફેન્સ નથી બતાવેલા એટલે નથી આમાં નેરેટ કરી શક્યા પણ
2015 જેલમાં
અને નાસિક જેલમાં છે અને આ છે ત્યાર પહેલાનો જે ગુનો છે એના હસબન્ડ સામેનો એ સાહેબ પૂરો થઈ ગયો છે અને કાલિકા પ્લોટ વિસ્તાર છે મોરબીમાં એમાં એ 2021 પછી અહીંયા રહેવા આવેલા હશે અને પછી એને પકડવામાં આવ્યા છે. મોડસ ઓપરેન્ડી એવી છે સાહેબ કે કોઈ પણ વાહનમાં એના હસબન્ડને એને ચોરીમાં સપોર્ટ કરેલો છે, કોઈ પણ કેફી પીણું પીવડાવી અને કોઈ રીતે ખાલી બોલેરો ગાડી સાહેબ ચોરી કરવાના અલગ અલગ ગુનાઓ એની સામે જે તે વખતે દાખલ થયેલા છે એના હસબન્ડ સામે સાહેબ અને આ ગુનાના કામે સાહેબ એનો ક્લિયર કટ રોલ આવે છે અને એના હસબન્ડને મદદગારી કરી છે એટલે આ બધા સંજોગોને ધ્યાને રાખી સાહેબ જી બીજું છે.
જ્યારે નાસિક પુષ્ટિના ગુનામાં કોર્ટમાં જતા હતા જાગતામાંથી પોલીસ માઝમાં ગોળી પીવડી નાસી ગઈ ના એ લોકો મરિયમ પી ગઈ હતી જાતે એટલે બેભાન થઈ ગઈ એટલે રહી ગઈ અને બાકીનો ઘરવાળો ભાગી ગયો.
ભૂતકાળમાં સાહેબ પોલીસ જાપ્તામાંથી પણ ફરાર થયા છે એના હસબન્ડ અને એની સાથે સપોર્ટમાં છે એટલે ક્રિમિનલ જ છે અને આવા સંજોગોને ધ્યાને રાખી સાહેબ હાલના તબક્કે એની જે કન્ડક્ટ છે એનો જે ઇતિહાસ છે એ સાહેબ તપાસના કામે બધી પેપર્સમાં સામેલ રાખ્યો છે એટલે સાહેબ આવા સંજોગોમાં હાલના તબક્કે એને બેલ આઉટ નહીં કરવા વિનંતી.
હાલના ગુનામાં સાહેબ મોરબી સિટી બી ડિવિઝન પોસ્ટ ગુના રજિસ્ટર નંબર 610/23 થી આઈપીસી ની કલમ 379 આ ગુનાના કામે સાહેબ અમે જેલ હવાલે સાહેબ આ ગુનાના કામે એફઆઈઆર જોવામાં આવે સાહેબ તો એફઆઈઆર માં અમારું કે નામ બીજું કે સાહેબ ગુનાની જોગવાઈ છે 3 વર્ષની જોગવાઈ છે સજાની સાહેબ નીતિ કોર્ટને ટ્રાયલ ચલાવવાની સત્તા હોય છે સાહેબ આ કામે મુદ્દામાલ રિકવર થઈ ગયેલ છે સાહેબ અમારી પાસેથી કોઈ મુદ્દામાલ નથી મળી આ કામના આરોપી નંબર 1 છે એની પાસેથી મુદ્દામાલ સાહેબ અમે રાજકોટના સ્થાનિક રહેવાસી કે નાસી ભાગી જેવી વ્યક્તિ નામદાર કોર્ટ જે શરતો ફરમાવશે તેનું પાલન કરીશું જેથી યોગ્ય રકમના જામીન કરવા
જી સાહેબ અરજદાર આરોપી છે એમાં 2 આરોપી છે પકડી ગયા છે અને આજે આનંદ શાંતિલાલ જે છે સાહેબ ફરિયાદ એવી છે કે જે ફરિયાદીની ગાડી પોતે ટેક્સી તરીકે ધંધો કરતા હતા એટલે રાજકોટ પાસે એના રૂટીનમાં એની પોતાની ગાડી લઈને ઉભેલા ત્યારે આ 2 લોકો આવે છે કે અમારે અમદાવાદ જવું છે એની સાથે ટેક્સી તરીકે ભાડું નક્કી થાય છે અને પછી સાહેબ એ ગાડીમાં બેસી અને મોરબી પાસે આવે છે ત્યારે એક હોટલમાં હોલ્ડ થાય છે સોરી સાહેબ તો હોલ્ડ કરતી વખતે જે ગાડી છે એ ચાલુ રખાવે છે અને એ પોત એક જે છે આ આરોપી નંબર 1 એ સાહેબ ગાડીમાં બેસી રહ્યા છે. આરોપી નંબર 2 નીચે ઉતરે છે અને ટેક્સીના ડ્રાઈવરને વોશરૂમ જવું છે એવું કહી અને એને નીચે ઉતારી અને પછી ફરીથી આ જે અરજદાર આરોપી છે એ ચાલુ ગાડીમાં પોતે બેસી જાય છે. અગાઉના આરોપી નંબર 1 તો ગાડીમાં બેઠેલા જ હતા સાહેબ અને ગાડી લઈ જતા રહે. એટલે કોઈ ઉતરતો રોલ નથી સાહેબ. બંને સાથે મળી અને આ ટેક્સી ચોરીનું પ્લાનિંગ સાથે સાહેબ ચોરી કરી છે. તપાસ ચાલુ છે સાહેબ. એટલે આવા સંજોગોમાં પ્રાઇમા ફેસી એમની સામે જે કેસ છે એ સાહેબ બને છે એટલે સાહેબ એને બેલ આઉટ નહીં કરવાની.
Where is Ramesh bhai? Mayur Singh Vikram Singh. Mayur Singh Vikram Singh. Other Daud bhai.
आरोपी नंबर 1 being exempted.
Say Nadeem bhai. Benjamin Ahmed bhai. Rahmat bin Akbar bhai. Basir Osman bhai. ऐसा मन दीजिए बुलाई.
जी भाई जी भाई बड़े सर
Executive magistrate Albert. Hey, Ramji bhai. अच्छा. क्या मतलब जी? Service start. Lincoln Jamal Khan. अभी start. Proceed, Mehboob bhai Pathan. Proceed, Mehboob bhai Pathan. Proceed.
વસ્તુ છે ને સાહેબ, એના મધરને રાજકોટ લઈ ગયા છે એવો ફોન આ પેલું હિયરિંગ ચાલુ હતું ને મારા ઉપર હતો સાહેબ કે રાજકોટ જઈ છે મારા મધરની તબિયત બરાબર નથી નહીં આપે એટલે સાહેબ એક આ ગ્રાઉન્ડ છે તો એનું જે તારી જરૂર હોય છે આવતી હોય આવી જાય. એવું મહેતાનું વીપી નથી હવે એમાં એ વિટનેસ પૂરતા જ હતા આમાં નથી.
Witness પૂરતા
એ વિટનેસ જે લીધા ને એટલા પૂરતું જ વીપી છે એમનું. ફરિયાદ પક્ષે
બે lady
નથી.
હતા ને એના.
પણ હું બોલાવી લઈશ આવતી વખતે sure. અને વહેલી ખબર પડી હોય તો હું તમને કહી દઈશ. મને
કોઈ
9:11 ફોન આવ્યો હતો. કઈ સાહેબ ભલે ઓબલે જોઈ લો સાહેબ મંદિર.
ડ્રોપિંગ પ્રોસેસ કઈ બાકી રહી ગયું અમુક વિટનેસ ને ડ્રોપ કરવાની
અહીં
પ્રોસેસ
તો હું આપી દઈશ આજે જોઈ લઈશ આપી દઈશ એમાં કોઈ પ્રશ્ન
એટલે
નથી.
શું
એમાં ગયા વખતે એના બે પુરસીસ બાકી હતી આઈપી ચેક ની વેરીફાઈ કરું સાહેબ એમાં નહીતર આપી દઈશ. ફરિયાદી છે સાહેબ અને હું રિપોર્ટ આપું સાહેબ આપવો તો અને બેલેબલ કાઢવું સાહેબ તો મને માનો નથી.
મોસીન અલીભાઈ મોસીન અલીભાઈ બેસો छोटेला राजा बेटा दुकान बुलाएंगे जय भगवान जी જગદીશ જસુભાઈ. Please. I Mehboob. I Mehboob. Premsing Jograbai. Premsing Jograbai. Premsing. छब्बीस चार Yes, sir. Please. Given by the two right. Or given by the two by. Karan Vijay bhai. Karan Vijay bhai.
આવ્યા છે બરાબર મુદ્દામાલ વેલ્યુબલ કંઈક બતાવવાનું હતું આ ટ્રેજરીમાં આપણે બે વખત રહી ગયું છે તમે ફરી વખત કોલ આઉટ થાય પ્રણભાઈ બેસજો જતાની પાસે બસ ના 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 એક મુદ્દામાલ બાકી છે એક 14 માં 2 તો શરૂ કરી છે 1 14 માં એની અટકી છે સર તપાસ મુદ્દામાલ નહીં હા જોઈ છે ને એના માટે તો વ્યક્તિ છે મુદ્દામાં
એમાં જોશે
એમાં જોશે એમાં જોશે એટલે બે વેલ્યુએબલ છે ને એટલા માટે ઓકે પંચો બાકી છે એવા છે ચાલુ કરું પંચો છે